Hello everybody and welcome to the first of our Landlord Law Legal Cases webinars, which is going to be on the case of Pease and Carter. The barrister who's going to be explaining the case to us today is Alice Richardson. Alice is a specialist landlord and tenant barrister who deals with housing and property work, and she's based in Trinity Chambers, which I think is in Leeds, isn't it, Alice?
Yeah, we've got one in Leeds, one in Newcastle, and I'm in the Newcastle branch.
So Alice is going to be talking about Pease and Carter, which is all about mistakes in Section 8 notices. So, Alice, would you like to explain the case to us, starting perhaps with the background to the case?
I will, yeah. I've set out on the slides here what we're going to cover. So the background to the case, a bit about Section 8 notices generally, the issues that this case raised, why it went to the Court of Appeal, the arguments that were used at the hearing, and then the wider implication for notices and other possession notices. I was counsel for the landlord in this case, and what had happened was the landlord had granted the tenants, as two tenants, on the slides I've just called them T and L, an assured short-hold tenancy back in 2007. The property was actually, I've described it as a cottage. It's some kind of small stone building on quite a large estate. My client, I think, lived in the main house and owned the entire estate. The tenant actually worked for my client on the estate as some kind of maintenance man / handyman. So there's an interesting dynamic between the parties. The rent was originally £800 a month and was subsequently reduced later on to £500 a month. Something happened between the parties leading to the tenant to quit his job working for us in around March 2018 and subsequently stopped paying rent in April 2018. Not within my experience or within this relevance to our case, but there was a separate claim brought by the tenant against the landlord in the employment tribunal as an employee against an employer for an unfair dismissal, which he also lost. So there's all sorts going on in the background to this case that aren't necessarily relevant to what we were talking about.
Yes, I mean, just thinking that situation, I mean, sometimes in that situation, the tenant will have a service occupancy rather than a tenancy, won't they? So I assume that the tenant wasn't required to live in the property because of their work, which would have...
No, I think, I might be wrong, but I think that actually when he first took up the tenancy in 2007, I don't think he did work for us. Mm-hmm. I think he later worked for us, and maybe that was why the rent was reduced later on as a part of that relationship. But no, he was definitely being granted a fully assured short-hold tenancy rather than a service occupancy. Otherwise, we probably would have never been in the difficulties that we subsequently got into.
Wouldn't have had a problem, yes.
So this is in March, April, there's no rent being paid, and we get to November of 2018, and the landlord's agent serves a Section 8 possession notice on the tenant, well, on the tenants, because it's a tenant and his wife, worker and his wife. The renter is by that point over £3,500. The notice was signed and dated on the 7th of November 2018, but there was a typo, which was that we'd said that court proceedings would not begin until after the 26th of November 2017, rather than the 26th of November 2018.
It's easily done, that, isn't it?
It is easily done. It's probably surprising to do it in November. In January, you can understand how easily done it could be. November, these things happen, I suppose, and it's a fairly straightforward error, and what I thought was a fairly obvious error from the very beginning. The standard note on the form, on the prescribed form that we'll talk about a bit later, says that where the landlord is seeking possession on the grounds that we were relying on, court proceedings cannot begin earlier than 2 weeks from the date the notice is served. So served on the 7th of November 2018, said to expire, or the proceedings couldn't begin rather, until the 26th of November 2017 rather than 18. What does the law say? So kind of taking it a little bit back to basics, because most people will be no doubt aware of the two routes to getting possession on an AST. There's the Section 8 route or the Section 21 route. I'm just going to talk about those two routes a little bit, because you'll see when we come to what happened in this case that it was necessary when it came to the Court of Appeal for me to take them through both routes and what they mean and what the statute requires landlords to do to satisfy those. So no doubt everyone's aware, Section 21, commonly known as the no-fault route to possession. You've got to meet the now fairly lengthy preconditions before you can serve a Section 21 notice, and you can do so once the fixed term is expired. That's all kind of me generalising, but I think most people are probably familiar with the complications that there are to Section 21 notices now. And I don't know in this case, because I wasn't involved at that stage, but I suspect there's reasons why we went down the Section 8 route rather than the Section 21 route. There is now a prescribed form. Most people, when they serve a Section 21 notice, nowadays will use the 2-month and a date specified as the last date of the period of the tenancy, plus a savings clause to say, or if that date's not the last date of the period of the tenancy, whichever date is, which avoids the type of problems that some of the cases that we're going to talk about got into. But that's the basic for a Section 21 notice. Section 8 notice, again, most people are probably aware, it's basically landlord proving a breach of one of a number of grounds. In this case, and what's relevant to this case of rent arrears, the grounds are set out in Schedule 2, and there's mandatory and discretionary grounds. As we'll come on to in our case, we're relying on all of the rent arrears grounds, so both mandatory and discretionary. Again, there's a prescribed form, and you have to use a prescribed form or a form that is substantially to the same effect. Now, in that form, anyone who's seen it knows you've got to include certain details, including the date that possession proceedings will not begin earlier than, and you set out the date. And the Act provides certain timeframes for various grounds, although at the moment they're all 3 months because of the situation we're currently in. But usually, for the grounds that we were relying on, there was 2 weeks, as I said earlier. These are the grounds that we were relying on. The ground date, as everyone knows, mandatory if certain thresholds are met, i.e. in our case it was a monthly rent, so 2 months rent in arrears. And then grounds 10 and 11, some rent arrears or persistent delay in paying rent, the discretionary grounds. Anyone who doesn't know, if there's a mandatory ground for possession, generally means the court does not have jurisdiction, or doesn't have, discretion to do anything other than make a possession order if those conditions are met, whereas under discretionary grounds, they have to consider whether it's reasonable to order a possession order. So,
yes, I mean, just chipping in there, often landlords will use the rent arrears ground because they also get a CCJ along with the judgment as well, so that it's sort of like a job lot, so they if the tenant's got any money, which is usually the problem, they can go and enforce it. I think also some larger landlords will go down that route as a matter of principle, because they'll want there to be a CCJ against the tenant if they don't pay.
Yeah. It's also, I suppose, in some ways a better way to protect yourself, because there are, in my experience, maybe it's because I'm a barrister and things only come to me when they've gone wrong, but in my experience there are lots of things that can go wrong with Section 21s because there's not the same checks in place.
Yeah, but conversely, there's a lot more defences that tenants can bring into Section 8, like saying that, there's rent arrears, that there's repairs that need to be done and so on. So, I suppose it's swings and roundabouts, really.
And that is something that happens, you'll see in this case as well. So to add to the notice problem, there's various other issues. I mean, this is one of those cases, everyone has these cases occasionally where everything that could possibly be raised and thrown at it is raised, and every kind of possible problem that you could run into, you seem to run into. But the first problem was obviously the date was wrong on the notice. So there was an argument that it didn't comply with the Section 8 requirement to give that date, and that's obviously a statutory requirement. The regulations provide for you to do so. And I don't know about you, Tessa, but in my experience, the court's approach when there was an error has often been quite a strict approach, which is to say, right, notice isn't valid, off you go, and the landlord will have to go and serve a new notice and issue a fresh set of proceedings.
Yes, I mean, I can understand that actually, because I think a lot of judges take the view that they are depriving someone of their home, which is quite a serious thing because, they are potentially being made homeless. And, sometimes if people are made homeless, it sort of knocks them off life's perch, as it were, and sometimes they never get back on again. And if they've got kids, they might get taken into care. It's a very, very serious thing. So I can understand why the court's approach is strict.
Yeah, definitely. I suppose the difficulty is if there's any kind of rule with no flexibility will always lead to potentially unfair results. So if we had an approach that we did previously, which not across the board, but generally seemed to be, like I say, that quite strict approach, that did lead to circumstances where you might be a landlord with, as in our case, not insignificant rent arrears. And if you had to go away and serve another notice, go through that notice period again, serve proceedings again, wait for a hearing again, the rent arrears are going up and up.
Yeah, I mean, I suspect what a lot of people are saying to themselves is, when did they spot this error on the notice? Why didn't they serve another notice before the proceedings were issued? Because the notice period is only 2 weeks. It's not like Section 21 where you've got a 2-month notice period. Yeah. I mean, did they not spot it before they issued proceedings?
No, no one noticed. They issued proceedings. A first hearing was listed, which I think I'll come to now. And that was at the end of January 2019. So
can I just ask, did they act in person or did they use solicitors?
So for the notice stage, I think they used an agent and then they instructed solicitors to issue the proceedings.
I'm surprised the solicitors didn't pick up on it.
Yeah, so we get in front of District Judge Adams in Darlington, who immediately looks at the papers and says, well, hold on, this notice is invalid.